Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about a public company, and this is a public company that has an obligation to have its accounts audited. And what happens in today's litigation is that this public company comes to court to try to get an order pursuant to section 13224 of the Corporations Act in relation to the auditing of these accounts. Now let's do a bit of factual background first to find out why we're having a journey into this section of the Corporations Act. As I said, we've got this public company, there are these obligations for it to be audited. From about 1970, we have got a person, let's call them MXA. We've got MXA, and from about 1970, MXA or entities related to MXA are causing the public company's accounts to be audited. We've got A and partners and A accountants and A advisors. The names change of MXAs like related professional service entity over time, but in essence, MXA themselves or MXA's related entities are performing this auditing function for the plaintiff, for this public company, over time. Now, in about 2015, MXA passes away, and MXA's child, who's also named MXA, comes into the family business, and MXA is an auditor themselves, and MXA Junior continues the auditing work from the death of MXA Senior in about 2015, and the description of the firm A partners or A advisors or A accountants or whatever it may be continues to be the description on the relevant audited accounts. We have this sort of handover on the date of MXA Senior's death to MXA Junior. So from about 2015 or so, 2016, till about early in 2025, we have MXA Junior doing the auditing work. Now, as time passes, there seems to be a bit of a difference of opinion between MXA Junior and the board of the plaintiff, and there are some disagreements that occur, and those disagreements essentially lead to MXA Junior resigning as auditor of the plaintiff. Now, what happens at the time of that resignation is that it becomes clear that MXA Junior, at about the time of MXA Senior's death, when there was that changeover, was in fact not validly appointed as an auditor of the plaintiff, which meant that the plaintiff was going ahead as a public company, nearly said a funny word there, going ahead as a public company, and on the basis that it was not having a validly appointed auditor in place. Now, the challenge of not having a validly appointed auditor in place is that it would put the public company, public company plaintiff in breach of its relevant obligations under the Corporations Act. And that was a challenge that the plaintiff had to face, and that is why the plaintiff came to the party with its section 1322 subsection 4 application today. The nature of that application is that the court can declare certain contraventions of the Corporations Act to be not invalid if they were sort of honest mistakes, and if a declaration like that wouldn't prejudice or wouldn't put any other person in an improper position. And so what the court had to do was to work through evidence of what had actually happened with MXA Junior and sort of the firm being run by MXA Junior's appointment from about 2015, or 2016 was it? You'll have to flick back to earlier in the video to find out. But importantly and crucially, what was found was that MXA Junior and the firm at the direction of MXA Junior was indeed doing the auditing work, so the auditing work was getting done. The auditing work was getting done otherwise consistent with the relevant standards and whatever else that might apply to the doing of the auditing work. MXA's entity was getting paid for the auditing work, and so sort of on paper, the sort of day-to-day, week-to-week sort of issues were being attended to. And so the plaintiff came to court to seek this declaration to say, hey look, could we please have this apparent contravention of the Corporations Act be declared to be not invalid? Now, a number of little fiddly things have to happen here in order for this section to be satisfied. Firstly, the court's only going to give an order like this if it can be shown that the sort of mistake or the contravention is procedural in nature. If it's some big ugly thing, then this section may not be the section to look at in relation to relief. Secondly, there has to be this position of honesty. Thirdly, there has to be the fact that no one else is going to get prejudiced, no one else is going to be put in a difficult position in the relation of this. So the court looks through the evidence. The court finds that indeed it's a procedural issue. Did you tick the correct boxes and pass the correct resolutions at the meeting in relation to the appointment of the auditor? So the court was satisfied, yeah, this is the kind of stuff that the section applies to. Next, on honesty, the court looked through in some depth the various records and board meetings and sort of reviews of its own records that the plaintiff commenced and that sort of thing, and found, yes, indeed, the contravention was honestly made. Everyone thought the auditing was going fine and the auditing was appropriate, and there was no intention or anything like that to contravene the terms of the Corporations Act. And thirdly, the court thought about shareholders and thought about other people who might be relying on the audited accounts and that sort of thing, and found, yeah, the members, the shareholders will be fine, and other people in reliant on it will largely be fine as well. And so the court has a discretion pursuant to section 1322 sub 4, and the court elected to exercise its discretion in favour of the plaintiff's application after making a couple of amendments to some of the declarations and orders the plaintiff was seeking. One of the important ones that I would have referred to in passing earlier is that the court was not prepared to order to say, yes, indeed, the plaintiff and its directors were in compliance with their duties and what they did was valid. The way the section works is sort of almost the inverse of that, is that you need to make an application that is reasonably precise, and you need to seek an order saying the very specific contravention of this little section here is not invalid, rather than an overall declaration of validity in relation to the whole exercise. And the court notes, yeah, well, we don't have evidence about the validity of the whole exercise, but we can declare that what would otherwise have been invalidity pursuant to this very little section of the Corporations Act, we can declare that it is not invalid because of that particular contravention. Hope that makes sense. Look forward to joining you again soon for another coffee and in respect of another case note. Cheers.